Joanne, hi.
Ben. Hi Ben, how's things?
Yeah, good, thank you. Good. So, Francis has returned to the county court, this time for a now unopposed lease renewal. The judgment looks pretty dense to me, quite hard from an outsider's perspective to get into. So, what do we think are the key takeaways?
That's interesting. I mean, I don't think it's going to change the law. We went to the Supreme Court and did that there. It's really about the application of, well-established principles about lease renewal. But yeah, so takeaways are, I think the key thing is a really, really big drop in the rent for the new tenancy. So the old tenancy was at 220,000 a year, new tenancy granted at 102,000 a year. So you can see the impact of COVID on it. And also a few bits and pieces which may be interesting on interim rent as well.
Yes, well, maybe we can come on to those. I mean, one thing that jumped off the page of the judgment to me was the criticism that the landlords expert had for, in essence, being biased.
Yeah, there is really quite strong criticism. And I mean, you and I know as advocates, we quite often make these points in cross-examination, but we don't get anywhere with them. But this time, the judge really did think that those points had landed. And although he had some criticisms of the way in which my expert had also dealt with things first time round, when it came to sort of disputed points on a number of points, he was prepared to say, well, I'll go with Mr. Buckingham, that's the tenants expert, rather than Mr. Holland as the landlord's expert, because I think Mr. Holland has lent too far towards favouring landlords.
I mean, it's a problem that we often see in these cases because the experts are involved to negotiate on behalf of their clients, and quite often these experts are also involved in determination where they act themselves as advocates. So they descend into the arena all too easily.
Yeah.
And it really can come back to bite you.
It really can, and it can come back to bite the party calling that expert. That's the other thing, sometimes I think clients think, well, if I put a bit of pressure on my expert, they'll say what I want them to say, but actually that can really backfire, can't it?
Yeah, absolutely. Well, I mean, a second thing, again, from a relative outsider's perspective, as I wasn't involved in it this time, that I saw was just, I was reminded of how technical these cases really are. There is so much going on. There is quite a lot of really quite complex expert evidence. And I have to remind myself to treat these cases with respect, that we do a lot of them settle, and it's very easy to think, oh, well, I'm not going to pay so much attention to it. But really, they are hard work.
Yeah, the devil is really in the detail, isn't it? And, a few percentage points here or there, a particular discount, accepted or not accepted, they can have a big impact on the ultimate rent figure, can't they? And I know valuers are really used to that, but you're absolutely right. It can be quite difficult for us as lawyers to really, really get under the skin of these things in advance of a trial, and very difficult to advise our clients as to what's likely to be the outcome, can't it?
Absolutely, because if it's hard for us, it's hard for a judge too, in often quite short trials. And the issues are so complex and the judgment can be so compressed that actually it means that there's quite a big margin for error or surprise. I mean, one point that jumped off the page to me was the frontage to depth analysis, because that can be a real minefield. You have experts that not only they don't agree on the methodology, but they won't even agree the purpose behind a frontage to depth discount. And here you have a judge who's in essence stood back and said, looks like a pretty wide frontage to me, so I'm going to give you 20%.
I'm not sure it's quite that simplistic, but I think what is interesting is that so one expert's at 5%, the other's at 25%. You might say, oh well, the judge will come somewhere in between, but he didn't. He went very much with one side's expert, and it just shows that we can't always, expect a fudge. Sometimes the judges really are prepared to accept one side's evidence over another's.
Yeah, absolutely. I mean, another aspect of that was rent-free periods as well. Another really technical point, and one that I've spoken about recently as well. What did the judge do on rent-free periods?
Yeah, so that there's a bit of an issue doing the rounds as to whether a 54 Act tenant gets the benefit of a fitting out rent-free period. Actually, that didn't feature in this case. Ultimately, it was raised as a possible issue along the way. In fact, when we heard that judgment was given in the case that you did recently, before His Honour Judge died, but ultimately the landlord decided not to take the point, and so the rent-free of 12 months, which was awarded in the rental valuation, reflects both fitting out and incentive.
Right, and you managed to get 12 months, even though the key comparable, you had only 3 months of rent-free.
Yeah, but that was because the comparable was, I mean, it was the only comparable out there, but it was dissimilar in lots of ways, including a much shorter lease granted as part of a surrender and regrant, a regearing effectively. So I'm not surprised that the judge felt that that evidence wasn't conclusive of what the appropriate rent-free would be, and looked at other evidence of other transactions, albeit ones that didn't inform the underlying Zone A rent, as to what they were doing in terms of rent-free periods.
Right, yeah, there's always so much behind. I mean, each comparable is its own little story.
Yeah,
and you can keep digging, can't you?
Exactly, yeah, that's right.
Well, the obvious big point as well in this case was interim rent, as you mentioned. And before our chat, I was just reminding myself about which particular interim rent provision this fits into, because this isn't the common unopposed lease renewal interim rent situation under Section 24C, where there's a starting presumption that the interim rent will be the same as the rent. And if that's then rebutted, then in essence, it's fixed as if the new lease had commenced on the interim rent valuation date. It's not that, it's a Section 24D. So that means it's in essence the rent that it's reasonable for the tenant to pay, but we have to have regard to the passing rent under the current tenancy, and we value it on the basis of a yearly tenancy.
Yeah. Yeah.
Now, the rest of what the judge did, perhaps you can help me with.
Well, I think the thing to bear in mind is that there were a number of really, really unusual factors about the interim rent calculation here. The first and foremost is that the interim rent is payable for a really, really long period of time, because the application for a new tenancy had been made many years ago, and it had taken such a long time because we'd gone up to the Supreme Court and then we'd come back down and had to crunch through. Actually, the valuation date for the interim rent was January 2016. And that rent will be payable all the way until the new tenancies are granted, 3 months and 21 days from the date of the judgment. So you're looking at a really unusually long period for interim rent. That's one thing that's unusual. Another thing that was unusual was that there was effectively only one side's valuation evidence on the year-to-year rental values, because whilst the tenant's valuer had put forward a yearly rental value, the landlord had not valued on that basis. The landlord's valuer said, well, you've had 5 years of occupation, so I'm not going to treat it as being a yearly tenancy. I'm going to treat it as if it was a 5-year period, which is legally wrong, was accepted to be legally wrong. So there was a bit of an imbalance, evidentially, with the judge having only one side's evidence on that. And the third thing that was unusual is that the passing rent, which had been set at a rent review in 2011, was artificially inflated by some particular hypotheses on the rent review, which had the effect of increasing it over and above the ordinary market rent. So when the judge does the balancing act, he takes into account the yearly rental value as at January 2016, but he's also taking into account the passing rent, but he recognises that that is too high. He's also looking at the rent for the new tenancy, which is much lower, obviously influenced by COVID, decides that's too low and comes out at 160,000, which is a bit higher than the rental valuation, the year-to-year rental valuation, but not up at the passing rent.
It's just another example of how difficult these things are to predict, I think. Well, that was really interesting, Joanne, and thank you for that. And I'll look forward to seeing you soon.
Yeah, catch up soon. Bye.